Welcome to this free immigration help channel. Today is November 9, 2023, and we are getting into the volume 174 of me answering your immigration related questions. As always, before beginning this video, I'm going to mention, as I mentioned in every video on this channel, I am not an immigration attorney. This is not legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question from Wahid Iqbal, TB8SM. I'm a self-petitioner for EB2, so employment-based, NIW. What option I will, so national waiver, what option I will select for my spouse, children in the petitioner information select list? So that was a question on DS260. Vahid, I'm definitely going to need a little bit more information on this one. So I'm assuming you're trying to add your spouse, your children, your family members to the DS260 as dependents, I'm assuming. But here's the thing, whenever it comes to the DS60, because it's online form, depending on what you are, depending on what you're filing based on, the field's gonna populate differently. So if you can, please come back to this channel and let me know what the options are, and I think that way I can definitely help you better than just from very generic petitioner information. So if you can, please let me know. I'm gonna need additional information. I'm gonna type it up later. I'm gonna put the answer. Let's move on to the next one from Christina's 3606. My cousin filled out the I-134A. Okay, so that's a program for the Ukraine and a few other countries. The program that is available where anybody can sponsor a national of Ukraine, or there's a few other countries out there. I'm pretty sure it's Nicaragua, Venezuela, Honduras, and there is another country there. So anyway, my cousin filled out the I-134A and the beneficiary was not able to come in the time. Oh, I see, they sent. Now I redid the I-134A for the beneficiary, and the beneficiary got the acceptance notice. Great, okay, but the travel authorization was not sent. It's been more than 2 months. Since he didn't go the first time, will they give him authorization to travel to the US the second time? Christina, that's a very good question. Unfortunately, I can't tell you for sure because it's a newer programs. Well, here's the thing. Let me correct that. These programs, they've been always around, okay? Whenever it comes to, crisis in another country, USCIS, the Department of Homeland Security, they through Congress, the Congress, they, come up with a legislation, and then Department of Homeland Security, they open up programs through USCIS for potential immigrants to come from the countries where there is crisis, because there is something, there's war, there's the bad situation, right? But because of the nature, because of the way these programs, because you have to keep in mind that these programs start up and then they end. So with that being said, all of these rules, they are very unique to each program. So it's very well possible that they might look into this. You got the letter of acceptance, which means they accepted the application, but when they review the application, they might look into it and say, hey, we already gave a travel authorization to this person and they did not use it. So what is the reason why they did not use it? The reason really doesn't matter, because, well, if they did not come when they had an opportunity, maybe potentially they are not in that much danger or in that much distress as they're claiming to be. Now, obviously, that's, I am being worst case scenario, but it is possible. It is definitely possible that they might come to that conclusion and say, no, we can't issue another one. But what I would recommend you look at to kind of help the situation, how long did it take before they did issue the travel authorization on the first application? And if it did take, a couple of weeks and now it's 2 months, then yeah, definitely it's a red flag. And I would probably recommend, if you are willing to continue fighting for this person to come here, I would definitely recommend looking into finding an immigration attorney and actually working with them if it has been a lot longer than the first time. But at the same time, they can look at it and say, oh, okay, this person has been approved before. Hopefully you were able to provide some kind of explanation why they were not able to travel the first time. And they might look into that and say, okay, yeah, so they had a valid reason that they were not able to come the first time. So here you go, the second time issue. So it can go both ways. But just in case, to be prepared, it's always better to be prepared and, not actually use any of that. But just in case, I would recommend reaching out to an immigration attorney. So let me post the answer here. And we're going to move on to the next one from Ushak Hatka. 6270. Hello, my child under 21 resides out of US and will age out in the summer. Okay, so I'm assuming the summer next year, summer 2024. I'm green card holder and petitioning him. Is there any form to be submitted alongside I-130 in order to lock his age? No, there is not. Or will it freeze automatically once I file I-130? Okay, so whenever it comes to anybody, whenever it comes to family reunification cases, anything other than immediate relative cases, the age only freezes under the CSPA, which is the duration of time it's pending with USCIS. So in your case, because it's going to be F2A, one of the 4 family preference categories, the age technically does not freeze, but under CSPA, it only freezes for the amount of time that the case will be pending with USCIS. So, with that being said, I highly recommend just file that I-130 as soon as possible. Today. Just file it today. Because the sooner you do it, the better, obviously. Because you really, really are short on time. Now, if we look at the visa bulletin for the F2A cases, looks like as of right now, they are taking about roughly a little bit less than 4 years. Roughly. Now, that might speed up, okay? But roughly about 4 years. With that, if you keep that in mind, if the case is pending with USCIS for a year, even 2 years, it is still not going to be enough time, as of right now, for your child to go under the F2A, because they will age out. Because by the time the case is reviewed, transferred to the NVC, which is, I'm pretty sure it's going to be less than 2 years for the F2A. Let's take a look at the actually USCIS and see how long it takes right now for the people in F2A category. So let's see, check case processing times. And because I don't think you have enough time, even if you file it literally right now. So permanent resident filing for a spouse or child under 21, there you go. Depending on which service center, I'll just select all field offices to get the overall. Okay, so 67 months. Wow. So sounds like you might have actually enough time. So 67 months. Let me do some math here. I'm gonna divide that by, let's see, so 67 divided by 12. Okay, so that's over 5 years, 5.5 years, which doesn't really make a lot of sense because the whole backlog is less than that. So they not updated this yet. So this is not updated. So this is gonna drop down because the visa bulletin recently updated and the F2A moved quite a lot, and looks like they still have not updated this. But as of right now, it says 5.5 years. If it does take 5.5 years for them to review your case, it means that under CSPA, you will be able to subtract 5.5 years from the total age by the time your case gets to the NVC, which again, it still might not be enough because it is so close. But by then, you will be able to, hopefully update your case from F2A to F1, which honestly doesn't really do. It's. In the conclusion, really, in this answer, you might not have enough time, but I would recommend it still filing it as soon as possible because, it really is close. It really is close. But no, unfortunately, it does not. It does not freeze like it does for immediate relative. If you're an immediate relative category, and you file, your child might be, aging out 2 months from now. But if you file it today and the age freezes, and no matter how long the case takes, that's it, the age is frozen because the day that they received the application, that's it, the age is frozen. But it's not like that, unfortunately, for the other 4 family preference categories, unfortunately. Okay, let me post the answer here, and we're gonna move on to the next one from Fada Moslast 3988. Hello sir, sorry I'm a bit confused here. My priority date is September 2014. I got documentarily qualified August 2023. Okay, Embassy Dakar, and I haven't received an interview yet, but I have received 60 days notice. Sir, can you give me a rough estimate when I can get an interview? Thanks. Okay, so Fada Moslast, I definitely gonna need to know the family preference category. Which family preference category are you in? Because that I need in order to look at the visa bulletin. But what you're doing is you're looking at the visa bulletin. Your priority date is September 2014. You're already documentarily qualified, so you need to look at the graph A. So whichever family preference category you're in, for example, if you are, let's say, F2A, and your priority date is, well, it's not going to be F2A because you're too close. I would think you're probably around, you're either F1, F2B, because you're close, but you're also possibly can be in F3 or maybe F4, but you wouldn't be documentarily qualified if you were in F4. Possibly F3, but most likely F2B or F1, which means that your immigrant visa should already be available. And you should have your interview scheduled pretty soon. The only red flag I'm seeing to this estimation is that you've been documentarily qualified in August 2023. And I would think that you would have been documentarily qualified earlier if you were in F1 or F2B, unless there was some kind of delay in the case. So if you can, let me know please in the follow-up comment your family preference category, and I'll try to give you a better estimate. Okay, moving further to Stunner Ducks. Stunner Ducks, thank you very much for being publicly subscribed to this channel. I appreciate that. So Stunner Ducks says, thank you sir for great information. My question is, how long will it take for the NVC to send you a welcome letter after receiving receipt number from USCIS on January 12th, 2023? Okay, so it's been about January 12th, so like 10 months now. Case I-130 petition for alien relative minor child of LPR. So you're an F2A. Okay, so you're an F2A, your case has been approved. Stunner, if you can, let me know what the priority date is, because we go from the priority date. But because you have been documentarily qualified, well, not documentarily qualified, you were approved on January 12, 2023, and they sent it to the NVC, and it's been about 10 months. Let's take a look. Let's see. So the F2A right now is February 2019, and let's see, F2A is September 23. So here's the thing, here's the problem, right? Because right now on the visa bulletin for the graph B, it shows pretty much being current, okay? So it's like 2 months. And your case has been already with the NVC for 10 months, and you still didn't get the welcome letter. I would recommend reaching out to the NVC, submitting a public inquiry form, and letting them know, saying, hey guys, I'm in F2A category, and and it's been approved by USCIS back in January, and it was sent to you, and it's been 10 months, and I still didn't get the welcome letter. So I was wondering, because judging by the visa bulletin, you should have gotten that welcome letter already, because judging by the visa bulletin, well, whoever applied in September 23, which is 2 months ago, basically, meaning that once they do get it from USCIS, an approved USCIS I-130, the portal is pretty much immediately open, and you get the welcome letter. And you didn't for a whole 10 months, so something is a little bit off. So definitely public inquiry form. You can find it here in Contact Us. I'm gonna show you how to navigate, and I'll copy the link and paste it so you can actually get to it easier. Okay, so here you go, public inquiry form right here. I do have the video on how to do it, so I'm not gonna explain how to do it here. Here it is, the public inquiry form, just your NVC case number. You might not have it just yet because you do not get the welcome letter yet, but you definitely have the USCIS receipt number for your I-130. So post that here. Principal applicants would be the beneficiary's full name, principal's date of birth, beneficiary's date of birth, petitioner's full name, obviously, who you are, beneficiary, petitioner, your email, and then in the inquiry, you can let them know saying, hey, identify your case, explain the situation. And they typically are pretty quick to respond to these inquiries, and hopefully they will be able to give you more information. Again, most of the times, unfortunately, they respond with a very generic boilerplate response, but it's still, you still do need to submit that. You do need this correspondence if you need to dig in deeper and work with an attorney or whatever. If you do need to keep sending these inquiries, this is where you start. So you have to do that regardless. Okay, let's move on to the next one from Kiorin 5237. Kiorin, also thank you very much for being public subscribed. Appreciate that. So Kiorin says, hello, I'm the petitioner for my spouse. I'm living in USA. I'm a USA citizen. We are married. My spouse lives in Dominican Republic. The priority date of my case is 27 June 2022. Okay, so it's been over a year now. Visa class is CR1, so immediate relative, conditional. And it was documentarily qualified on July 1st of 2023. How much longer do you think this will be for the interview to be scheduled? Kieran, thank you very much for your question. So whenever it comes to immediate relative category, once your I-130 is approved, that's it. The immigrant visa is already available. You're already documentarily qualified, so you're already done with the NVC, which means that the NVC already sent your case to the local U.S. embassy in Dominican Republic. And since it's been July 1st, which is now over like 5 months, about 5 months, over 5 months, I would think that interview has already been scheduled. The only reason why your spouse does not know when the interview was scheduled for is because they have to announce the interview 30 days before the actual interview date. They cannot announce the interview sooner than 30 days. So for example, if the interview has been scheduled for, let's say, January 1st, 2024, your spouse is going to find out about it on or around December 1st, 2023, a month before the actual interview. They do it because they give you 1 month basically to do the medical examination. I've seen some cases where they do it 60 days in advance, but most of the times, like 90% of the cases, if not 95 or 99% of the cases, it's 30 days. So with that being said, if you want, what your spouse can do over there, they can call the U.S. Embassy in Dominican Republic and say, hey guys, I'm documentarily qualified, my immigrant visa is already available, I'm an immediate relative category. I wanted to see if you guys can give me the date when my interview was scheduled for. Over the phone, it is unofficial scheduled. They just give you the date, but it's not an official announcement because you didn't really get the official notice from them. So sometimes they can give that information. Not all the time. In fact, most of the times they say we can give you that information, but it is worth a shot because I've seen cases where people call and they get the information. Don't be upset if they don't give you that information. I would say, most of the times it's about between 6 months and a year, usually. Personally, because I did have a case with immediate relative category, I-130 case, it took 9 months. So for you, it's been now July 1st, we are in November, over 5 months. So I would say it can possibly be another, 5-6 months. But most likely about 3 months maybe. So I would say beginning of 2024. But then again, it really depends on how busy U.S. Embassy is. In Dominican Republic, I'm assuming it might be a little bit more busier than regular, but I might be wrong. But give them a call. You can find their phone number on usembassy.gov website. Let's see if I can pull it up actually. Dominican Republic. There you go, Dominican Republic. And boom, there you go in Santo Domingo. Here's their phone number. Again, don't be upset if they don't give you that information because sometimes it depends on who you get over the phone. Just be polite and, And if they don't tell you, say, hey, thanks anyway. It's not a problem at all. Because you don't want to argue with these guys. It's really pointless. All right, let's move on to the next one from Beer Hanetai 6167. Hi, I almost documentarily qualified. Visa Bulletin priority. June 2022. When am I going to schedule, please? Okay, Berha Nitai. So in order to give some, and that's really for everyone, in order for me to give you some rough estimates, still gonna be rough, but as close as possible on the Visa Bulletin, I need three things. I need the number one, the priority date. Number two is the family preference category, whether you're immediate relative or any four family preference categories. And number three is chargeability area. So please let me know what the family preference category is, and I'll try to give you an estimate, but I definitely need that in order to look into the Visa Bulletin. Okay, moving further to Greg Brady. Thank you for your response and answer to my question. Yes, of course. Yes, what she did to me was one of the hardest things I've had to deal with in my life, and it has taken a heavy toll on me. What she did caused significant damage between my mother and I. She used us both. I'm healing from what she did, and thank you. A retired USCIS agent of 27 years told me that if my ex-spouse files for any other immigration benefit, that will be automatically flagged, and that USCIS wouldn't give her anything. Yeah, it definitely should be. So she's currently living in the country out of status under an expired student visa. Wow, this is horrible. And then Damage 459 says, any luck for a individual use 15 years ago brainwashed, they said divorce was enough. Ah, okay, I see what you mean, Damage. So yeah, 15 years ago brainwashed. Yeah, sorry guys, this is happening. This is a sad reality of this. And it goes down a lot deeper than it might see to the naked eye. It goes down a lot deeper because when you enter these your marriage relationship, right? It's no longer a marriage between in front of God. It's now a marriage in front of false God, who is now the government, right? And whenever stuff like this, whenever there are benefits associated with marriages, and whenever you're marrying someone and you're a US citizen, US permanent resident, and someone else from really anywhere else, there is that possibility, unfortunately, because there are benefits involved, of a person coming to the United States and becoming a permanent resident and becoming a US citizen, basically taking advantage of all these benefits that are coming from the world of the flesh, because now it's not in front of God. Because if you think about it, if it's a marriage in front of God, you are scared of God. You don't want to do that. You have a fear of the Lord, and you're not going to be taking advantage of another person in front of the Lord. If you're going at that, then, this is on that person, But in front of the government, who's afraid of the government? Yeah, everybody's afraid of the government, but whenever it comes to loopholes like this, taking advantage of other people in front of the government, and we do it all the time, and we don't do it just in marriages, we do it in business, we do it in politics, we do it in friendships, and fake friendships, not real friendships. Networking, we call it, all right? So, and yeah, if the marriage is now in front of the government and not in front of God, then what do you expect from a marriage? Do you expect it to be real? Because it can only be real if there are, if the marriage is by the Spirit. But we're getting into a completely different spiritual conversation. And on this channel I try to stick to the immigration only, but this is the reason why I made that video, Greg, on which you commented on, because I am an immigrant myself, and it really saddens me to see other immigrants like myself who instead of doing everything the right way, they unfortunately do things like taking advantage of other people in order to gain some kind of status. It's really sad, and it shouldn't be the case, but It's unfortunately part of the deal. Okay, let's move on to the next one from Vali HDH 1587. Hi, I would like to ask about parole case, as a parole petition was filed for me and my family almost 9 months ago. Yes, Vali, I remember. And successfully submitted and file numbers issued. I'm from Afghanistan living in Islamabad. I was expecting that we get the response within 3 months, but it's been almost 9 months that no response has been received. I'm desperately waiting for a positive response from US Embassy here, but sound they are very busy. Yeah. How long more should I wait, Valley? That's unfortunately not the question for me. I wish I could answer, but I can't. I have no idea. It really comes down now. It can be local. It can be local. It can be because the Islamabad embassy is very busy, and they just, there's too many people, and they can't handle all the cases. So there's a backlog that is accumulating locally in Islamabad. I mean, I think I already told you, contact the US Embassy, but at this point there is really not much that you can do, but really just wait, unfortunately. But yeah, unfortunately that's how it is. It's really hard to tell. Okay, so I'm gonna post a response here. We're gonna move on to the next one. Just thank you a lot from Shomo Abdulkrim. You're very welcome. I'm glad this was helpful. Moving further to Richard Torku 4427. Hello sir, I filed for I-130 for siblings on 4th January 2010. Could you please give me a clue on when I can get my visa? I filed for I-130 for siblings. Okay, so you filed for siblings, which means it's a F4, forced family preference category. So you filed in January 2010. Let's take a look at the visa bulletin. Right now we are on April 2007. So people with priority date in April 2007 in forced family preference category in all chargeability area, keep in mind. As of right now, they're getting their immigrant visas, they're becoming available. So you are January 2010, which is roughly 3 years away. So you got about 3 more years, roughly, if there was no delays on the case, if visa bulletin keeps moving the same way, which honestly it did not move for a while for the F4, so it might be longer. It might be faster because we might see some positive movement. It really is right now. It's a good time for you to keep checking the visa bulletin. Every single month the new one comes out on this channel. I do every time a new one comes out, I do a video on it and I compare it to the previous visa bulletin edition, so that you can see whether there was movement or wasn't for your category. But yeah, as of right now, roughly you have 3 more years before the availability of the immigrant visa, roughly. Okay, let's move on to the next one from DD24. Hi sir, when is the new visa bulletin coming out? And after becoming documentarily qualified, can you wait more than a year before getting an interview date? Okay, so DD24, I'm gonna start with your second one. Yes, you can. Absolutely, depending on which category you're in. A lot of times you're documentarily qualified 2 years, 3 years before your priority date is current on the graph A of the visa bulletin. So yeah, it's possible. You might be waiting 2 years before your immigrant visa becomes available. Because here's an example, right? For example, let's say you're in F1 category, all chargeability area, and your priority date, let's say, is let's say September 2017. So September 2017, you get your welcome letter to the NVC, for the NVC, you become documentarily qualified, and now you're documentarily qualified with a priority date September 2017. If that's the case, and that's you right now, as of right now, you still have this January 2015, my math is bad, so like 1.5 years to wait before your immigrant visa becomes available, judging by the visa bulletin graph A. So that's 1.5 years already. So you're already waiting more than a year for the interview. And then once your immigrant visa becomes available, you still have to wait before the US Embassy schedules the interview. So there can be additional 6 months to a year, depending on how busy the U.S. Embassy is. So yes, absolutely. In fact, most of the people who are in the 4 family preference categories, they are waiting longer after they are documentarily qualified for their interviews. Now, to answer your first question, when is the new visa bulletin coming out? It should literally be anytime now. In fact, let's take a look right now. Not yet, so still didn't come out, but this is the page. I'm putting the November visa bulletin link in the description below. From that link, you will have this page. From this page, just click on the visa bulletin right here, and once the December comes out, it will be right here, which it should literally be in the next few days. Probably it might be by the end of this week. Once it comes out, I will do a video on it. So if you're not subscribed yet, please consider subscribing. But yeah, it should be pretty close. So thank you very much, everyone, for asking your questions today. Hopefully the answers were helpful. If you have any follow-up questions, let me know in the comments below. Just make sure don't respond to my comment within your comment. Submit it as a separate comment, and I will be able to see it here on this wall. Thank you very much for watching. God bless, and I'll see you all in the next video.